Here at the Four Boxes Diner, I don't just try to tell you about what's happened and why it matters, although that's important. I also try to predict where I think people are going to go and why it's important to you. I'm going to tell you where I think the anti-gun movement in America is going to move to take away our rights. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, constitutional attorney, best-selling author, and proud American gun owner. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for our right to keep and bear arms. Okay folks, I have to make this a quick video, but this is a really, really important video. I've been observing where the anti-gun movement has been moving to, which is something that I've done over the years, and I've even written books on this topic, and I see their next move. I was thinking I knew where it was going to go. Now it's clear to me. I'm going to tell you in a quick second what it is. And that is this. Today in The Atlantic. Now, The Atlantic is a progressive, typical left-wing magazine, in my opinion. I think people would generally agree with me. It's actually a pretty good magazine. Has a long storied history of analysis and whatnot. So it's not a terrible magazine, but it's left-leaning. They're certainly, I would say, anti-gun as a general matter. I think that's probably fair to say, at least in my opinion. I think I'm probably right on this. But I want to tell you about an article, and this is really, really important because it is signaling where the anti-gun movement is going. It's critically important for you to understand this. Why? No gun companies means no guns. I repeat, no gun companies means no guns. No ammunition companies means no ammunition. Okay? Here's the key. The article today that was published is called "The Gun Industry Created a New Consumer. Now It's Killing Us." It's the subtitle of the article is "Good Marketing is Supposed to Generate Demand. Bad firearms marketing has given us a national nightmare." Now, you know where this is already going, I'm guessing. I'm going to give you the summary of the article in this following sentence from the article. Ready? "The gun industry's modern marketing effort did not just arm these shooters," referring presumably to mass shooters and criminal shooters. "In a very real sense, it created them." Okay, so what is this article about and why is it this important? This article, as I read it, is really about how the gun industry specifically marketed and sold AR-15s to millions of people. And this somehow caused the mass shootings and the criminal shootings using AR-15s and AK-style firearms because of this marketing. Now, let's set aside for the moment kind of the absurdity of the premise that marketing forces people to buy stuff they don't want. If marketing budgets forced people to buy things they didn't want, we'd still be able to watch Chris Wallace on CNN Plus. But despite the marketing spent on CNN Plus and Chris Wallace over there, doesn't seem like there is much demand. And also look at every woke movie that has done terrible at the box office. A lot of marketing money spent on things like Lightyear did not seem to perform as well as many people expected it would. Why is that? Because no matter how much money you spend on advertising and marketing, that doesn't mean that people want the product. So set that issue aside about the causal effect between gun-related marketing by the gun industry and people wanting AR-15s. We could talk about that in a separate video. That's not what this is about. The reason why I think the anti-gunners are moving in this direction is a bit of history here. Very clear history once you understand it, but it's important for you to understand this history. Ready? Before 2008, as a general matter, this is not completely true 100%, but it's basically right. Before 2008, the anti-gun movement was mostly focused on trying to ban handguns, stop handguns. Handguns were the preferred choice of criminals, etc., etc. But what happened was the District of Columbia, in the Heller versus DC case, before the Supreme Court made this very argument, the District of Columbia's lawyer, Walter Dellinger, a top-end Supreme Court litigator, argued to the Supreme Court in his legal briefs as well as orally at oral argument the following. He says, because we are allowing American citizens in D.C. to have rifles and shotguns, we are allowed to ban handguns. And the Supreme Court clearly rejected that. They said, nope. Not the case at all. Handguns are commonly possessed for lawful purposes by Americans. You cannot ban them, and they are allowed to use handguns in the home for self-defense and unlocked to boot. That's what the Supreme Court said. And 2 years later in McDonald, they reaffirmed this and said that you and I have a right to a loaded handgun unlocked in our home for self-defense under the Second Amendment. Now, these decisions by the Supreme Court told the anti-gun movement that trying to ban handguns was a futile effort because they weren't allowed to do it under the Supreme Court precedent. So what did they then do? They went all in, and they were trying to do it before, but then they really went all in because rather than spend money on trying to ban handguns, which was clearly unconstitutional, they devoted their resources to trying to ban long guns, rifles, specifically AR-15 style rifles and AK style rifles, right? They went all in because they were basically shut off from going after handgun bans because they were shut down by the Supreme Court. So they shifted their strategy to go after long guns, specifically AKs and AR-15s, right? That's where they went. And that's what they've been doing since 2010, nonstop. Assault weapons, weapons of war, assault weapons, weapons of war. You've heard it. It's all nonsense. It's all propaganda. We get this, but that's what they've been doing. But guess what happened? They got blown up. Their legal arguments got blown up, as I see it. In NYSERPA versus Bruin, as well as Caetano versus Massachusetts, which we talked about on this channel months ago, the critical importance of Caetano, which the Supreme Court in NYSERPA versus Bruin cited to. So in Caetano and NYSERPA versus Bruin, they set forth a standard that, again, reaffirmed that if a firearm is commonly possessed or commonly used by Americans for lawful purposes, it's protected. It's protected. So obviously, although NYSERPA versus Bruin was dealing with carry outside the home, clearly that standard they set forth would apply to AR-15s, AK-47 style rifles, and so-called large capacity magazines, which are really just standard capacity magazines. We all know this. So now we know that this standard that the Supreme Court set forth, it's very favorable in my view to stopping these bans of any of these commonly owned firearms, whether it be handguns or long guns or AR-15s or AKs. We see where the anti-gunners now see the handwriting on the wall. In fact, just a couple days ago, I did a video on this. A federal judge nominated to the federal bench by Barack Obama actually struck down temporarily, but I think it's going to be permanent because I don't see how the government can overcome the burden the judge set forth, struck down an assault weapon and a large capacity magazine ban in a town in Colorado, which I think is the sign of many more things to come, by the way. Okay, so let's step back for a second and pretend you're an anti-gunner, okay? If you're an anti-gunner, you realize that trying to ban handguns is foreclosed by the McDonald and the Heller cases. Then you sit back and you realize, although you can still try to mess around with so-called assault weapons, and I know the House is doing it. I think it's mostly for virtue signaling, by the way, because they know it can't go anywhere at the end of the day. They can't even pass it. And if they do pass it, it ain't going through the Senate. And if it gets through the Senate, which it won't, the Supreme Court's probably going to strike it down. I don't see how anyone thinks otherwise. But set that issue aside. So now if you're an anti-gunner, you know you can't ban handguns. And now under the new standard by Bruin, you probably are not going to be able to ban large capacity magazines or so-called assault weapons or AR-15s under the legal standard. So you're like, look, we can keep fighting it, but the reality is we're probably going to wind up losing. So now where do we turn? Where do we take all of our resources, all of our friends in the media, all of the people we know, all of our social scientists at the public health schools, all of our legal scholars? Where do we deploy them? Where do we deploy them? And the answer is I think they're going to laser focus on the gun industry. Why is that? Because you see, it's clear that the Second Amendment is going to be very protective going forward with this Supreme Court of the individual right to keep and bear arms, right? Very protective going forward, which is very good news. So that is not a fertile ground for the anti-gun movement to attack because it's likely at the end of the day going to fail. No guarantees. Anything's possible. They know that. They're going to fight it out. But odds are those arguments about assault weapons and large capacity magazines, blah, 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 are probably going to fail. So they know this. They're not stupid. They have excellent, powerful, smart lawyers. They get paid a lot of money. Got great scholars with great credentials. They're not dumb. They're smart. So if you look at the landscape of where the law is right now, what is a potentially vulnerable target? The answer is the gun industry. The gun industry. Because you and I can't buy guns if there's no gun companies. You and I can't buy ammunition if there's no ammunition companies. And I understand, look, you make guns, you have guns. I get all that. Guns are the ultimate durable product. They last for decades. I get all of this. So it's a little bit of an exaggeration on my part, but the reality is no gun companies means no guns. And I think that's basically the theme. And that is where the anti-gunners are going to target. So every time you pick up the newspaper now and you see a subpoena to Daniel Defense or to Smith & Wesson or to Ruger or any of these other companies out there, any gun companies, you can bet your bottom dollar that this is focused on trying to build what's called the marketing case. So how do they, in fact, let me step back. How are they going to get these gun companies? And I'm going to tell you how they're going to try to get them. It's pretty clear. They're going to try to argue that the gun industry's quote unquote marketing and advertising efforts somehow have caused murders, crimes, and mass shootings. They're literally going to try to say that advertisements and marketing efforts by the gun companies and the gun industry is somehow caused crime in America. Now, to say this is a stretch, I would say is, shall we say, conservative. Because to try to show, in my view, as a trial lawyer, to try to prove that some crazy psycho mass killer did it because of some advertisement he saw on the internet or some advertisement he saw, in a magazine somewhere, shall we say, is a stretch. And I would not want to try to prove that case in court as a trial lawyer because I know that would be very, very difficult. But with that said, I want to step back and explain why I think the anti-gun movement is going to laser focus on the gun industry and a particular part of the gun industry. They're going to laser focus on the marketing and advertising efforts of the gun industry. And why is that? Do you know why it is? I'm going to tell you why it is. Because I want you to be the smartest person in the room. That's my goal. In 2005, Congress passed the Protection of Commerce and Lawful Arms Act, or PICLA, okay? Now, you don't need to know that other than this. The purpose of that federal statute, which was encouraged by, among others, the Pentagon, was to make sure that the American gun industry was not destroyed by frivolous or near frivolous lawsuits, and the burden of litigation would not destroy them. Why is that? Well, first of all, we have a Second Amendment right. So if you have no gun companies, again, you have no gun owners, you have no guns, and therefore you have a problem with the Second Amendment, which is a fundamental right in the Constitution. It's written in there. The other reason, of course, is from the Pentagon's point of view, the military's point of view is, well, if you want to win a war, if you want to fight a war, if you want to defend the country, you need guns. Sure, you can have all sorts of other fancy weapons, that's true. But at the end of the day, you still need firearms. And who makes the firearms? Well, you really do want to buy those firearms from American companies rather than depend upon, let's say, Russian gun companies or Chinese gun companies or Turkish gun companies or whatever, right? At the end of the day, you want to make sure you have a robust American gun industry to make sure you have a robust American military using those firearms. You don't want to be dependent upon third-party countries in the event you have to go to war or protect the country from an invasion. So the military knew this, and they all pushed for this 2005 Immunity Act. But here's the kicker, and this is the key thing to understand. What the Immunity Act provided is this, that gun companies cannot be sued for third-party acts over whom they have no control that commit crimes. What I mean by that is this. I make a gun, I sell it to another FFL, and they sell it to a retail FFL, and they sell it to some guy after a NICS check, of course. They're going to have to run a NICS check. You're an FFL. They have to run the NICS check. And then someone uses that after the NICS check. They lose the gun. They use the whatever it is. A crime is committed by someone that the manufacturer of the gun had no control over. They've never even met the person. The wholesaler distributor had no control over the person that committed the crime. And presumably the retailer had no control over the third party. Because once they take that gun and pass the NICS check, they're out the door with the firearm. And whatever they do with it, they have agency. Whatever they do with it is what they do with it. The gun industry can't control that. And the federal law simply recognizes that, which, by the way, was an old line tort rule going back hundreds of years. Everyone understands that I can't be held responsible over the third-party conduct of third parties that I have no control over. Can't be responsible as a general matter. That's obvious. But that rule was getting nibbled away at in certain lawsuits in certain blue states by anti-gun litigators trying to turn that rule upside down, and it was costing the industry a lot of money, and people were worried the industry could go bankrupt, and they passed this law to make it very clear that if someone brings such a lawsuit, it would be dismissed right away. But here's the key part. It all sounds good so far, right? But here's the key part. This is the loophole. This is the loophole that the anti-gun movement is going to try to exploit. It's the same one they used in the context of the Sandy Hook lawsuit, which we'll talk about in a future video. In the federal statute, there were some exceptions to the rule, and they're very obvious exceptions. One of them was an exception that provided that in cases in which a manufacturer or seller of a qualified product, which is a firearm, knowingly violated a state or federal statute applicable to the sale or marketing of the product, and the violation was the proximate cause of the harm for which the relief is sought. You're like, what does that mean, Mark? It's really quite simple. That exception was very clear as I read it, it's very clear. It basically says that this federal protection we passed in 2005 is specifically designed to protect gun companies from the third-party criminal acts of third parties over whom you have no control. But what it's not designed to do is protect a gun company or a gun retailer from selling a product that, let's say, is fraudulent or you misrepresent its character. Let me give you an example. So let's say I am a gun retailer and I promise you, the gun buyer, that I'm going to sell you an AR-15 with a 30-round magazine for X dollars. That is our deal, okay? Well, it turns out I deliver to you not an AR-15 with a 30-round mag. I deliver to you a 15-year-old 5-shot revolver with no magazine. And I say, here it is. Well, nothing about that federal statute would prevent you from the buyer of the gun from suing me to say, hey, I didn't want a 5-shot revolver. I paid for an AR-15 with a 30-round magazine. You delivered. You lied to me. You misrepresented what you were selling me. You committed fraud. You deceived me. You sold me a 5-shot revolver. That's what that exception's about. But what's happened is the anti-gun movement is starting, as I see it, to publish studies and articles and all this kind of thing, talking about the advertising and marketing of guns in a way that they're going to claim is improper, was deceptive, was wrong, and they're going to gin up all this attention so that when somebody goes crazy and shoots up, commits a crime with a firearm, and there's a lawsuit against the manufacturer of the gun who had no connection to the shooter, they're going to try to use all these studies and all these articles and all this rhetoric and all this propaganda and all these discussions. They're going to throw it all into a complaint against the gun company to say, look, Judge, and they're going to stand in front of a judge and say, Judge, we are aware of the 2005 federal immunity statute, but there's an exception for false and deceptive marketing, false and deceptive advertising, and we believe that the gun company and their brethren in the industry participate in some sort of false or deceptive marketing practice about the role of these guns, whatever it is going to be, and they're going to try, and I'm not guaranteeing they're going to win, but they're going to try, as I see it, to fall within that exception to the 2005 Federal Immunity Act. That's where this is going. So going forward, I want you to mark my words. The anti-gunners cannot ban handguns. They're not going to be able to ban long guns. They're not going to be able to ban magazines, is my guess, based on the new legal standard. So they're going to target the gun industry. And they're going to try to do it by going after all the marketing and all the advertising. That's where they're going to move in their next legal theories. And they're going to try to bankrupt the gun industry with an exception, the marketing and deceptive advertisement exception to the 2005 Act. That's what this is all about. So going forward, when you look in the newspapers and you read stories about subpoenaing these gun industries, testifying to the gun industries, what the gun industry is this and the gun industry is that, it is not random. It is not random. It is part of a targeted effort, in my view, by the anti-gun movement to take out the gun industry because the Second Amendment has been robustly protected by this Supreme Court. And why do I believe this is targeted? Because they can't ban handguns. They're not going to be able to ban long guns. I don't think they're going to be able to ban large capacity magazines, standard capacity magazines. I don't think anything is going to work. So they're going to laser focus on trying to go after the gun industry that as of now has not been protected by the Supreme Court. And that's what they're going to do. And they're going to do it by arguing marketing and deceptive advertising. And they're going to try to do it by bringing lawsuits in the blue states in front of blue state judges and get blue state judges that have political aspirations to try to uphold these lawsuits that should be dismissed, in my opinion, as a general matter, but they're going to try to say, oh, well, we think there might be an exception here, so we're going to let them go into discovery, and we're going to let the gun industry and the gun manufacturer that's been sued, pay millions of dollars in legal fees, and to be distracted as opposed to focusing on improving the product and selling more guns, et cetera, and that's where I think the anti-gunners are going to go. So, okay, we're going to talk a lot more about this down the road, but I wanted to give you a quick heads up because this article in The Atlantic told me exactly, in my opinion, where I think the movement's going to go. And I hope you learned something here at the Four Boxes Diner. And if you haven't subscribed, please do so. And again, we'll see you soon here at the Four Boxes Diner.
Orders up. Table 2A.